In Mississippi, a federal judge is set to hear arguments today in a challenge to the state's law to ban abortions once a fetal heartbeat is detected. The hearing is the latest court fight since Alabama passed its law banning nearly all abortions in the state.
An opinion piece published Friday in the Washington Post explores the implications of new anti-abortion rights legislation being introduced around the country. It says if a fetus legally becomes a person as early as conception, the child could warrant support payments, due process, citizenship, all the other rights afforded a person under the law. So Carliss Chatman wrote that piece, and she's an assistant professor at Washington and Lee School of Law. Thank you so much for joining us.
Thank you for having me.
So you sort of, pull out this argument here to sort of the full extent of what this argument would mean, that a fetus is a person. You write that recent abortion bans, especially Alabama's, affect the rights of fetuses that are now considered persons under the law. What are the main questions that these bills raise?
The main questions they raise is whether states can actually define natural personhood. Previously, natural personhood just meant being born. That's what's under the 14th Amendment. If you're a human being and you're born, you're a natural person. Each of these heartbeat bills, particularly Alabama and Georgia, define natural personhood either at 6 weeks when you hear a fetal heartbeat. In Georgia and Alabama, it just states that, all fetuses and all unborn children are persons. What's interesting about it is that because it's not something that states have ever defined before, we can create this system of tiered citizenship where in a state that has an abortion ban, you can become a fetus as early as the day of conception, a person as early as the day of conception, and in other states, you're not a person until you're born.
So one of the issues you write about is how these laws affect immigration and citizenship rights. As Anne-Marie was pointing out, there's a whole slew of laws that would protect a person under the law. So how could that affect both immigrant mothers in the United States as well as their unborn children?
So under the 14th Amendment, once you are considered a person, then you have the rights of a U.S. citizen. We have birthright citizen in the United States, where if you are born in the United States, you are a U.S. citizen, and then you're also a citizen of the state where you are born. If we redefine natural personhood to some point during gestation, then presumably we'd have to rethink what we do with that 14th Amendment and what we do with when your rights as a U.S. citizen would begin.
I think it's sort of, that conversation is sort of interesting when you consider that it was the president that floated the idea of an executive order to revoke birthright citizenship. And everyone was like, no way, you can't do that, right? So Alabama Republicans have said that their law aims to overturn Roe v. Wade in the Supreme Court. The whole idea behind many of these laws is to eventually present a challenge in front of the Supreme Court to Roe v. Wade. But even if it's struck down, that doesn't make sort of abortion illegal nationwide, right? Because this is actually sort of a state issue.
Yes. So what Roe v. Wade does is says it puts a limit on how states can limit your right to choose. It doesn't say that abortion is legal or illegal everywhere. And so if Roe v. Wade is overturned in states like New York and Virginia and other states that have moved to protect the right to choose, you would still have the right to choose in those states. And so what we would have is forum shopping essentially for the right to choose. Women could go to New York or go to one of those states or just be born in one of those states and have a right that people in other states would not have.
So I guess one of the things that your story points out is it highlights the wide-ranging implications of these laws. I wonder, a lot of these lawmakers are lawyers themselves, right? Have they thought these through?
I don't think so. I mean, I think that, personhood in general and corporate personhood, which I write about, is a very, very niche area of law. And I don't think a lot of lawyers think about it. I find that, for example, the first corporate personhood decision was 200 years ago. And I find that I'm educating other lawyers about that. And so because it's not something that you would learn in law school or something that most lawyers deal with every day, I don't think the politicians are thinking about it.
Now, the politicians are, but lawyers should know better. And they know that some of these laws are sort of in violation of the Constitution.
And the Supreme Court, you would assume, would probably, once they're challenged, would take those into account.
But this is not necessarily only about the law. As we know, this is also about politics. This is about elevating abortion to the level at which it's a 2020 campaign issue. It's so much more complicated than just overturning the law.
Yeah.
Carliss, thank you so much.
Yeah.
Oh, sorry. Wait a minute. I want to hear from you because you're the smart one here.
Oh. Oh, no, I was just going to say that, it's kind of sad that human rights and, the rights of the unborn and the mothers are reduced to a political issue. I think it's a complex constitutional question. And, just as a scholar, it bothers me that, we are bringing morality and politics into something that's very complex.
Indeed. Carliss, thank you so much.
Thank you all for having me.